Hi there. Today we're talking about what happens if someone who's being sued does not defend the lawsuit. So the person being sued is called the defendant. We're going to talk about what happens if they don't defend that lawsuit. I'm Natalie Gerry, the principal lawyer with Gerry Law. I help injured people get the compensation that they deserve for their injuries. This is a common question that I get, well, especially if a defendant does not defend, but you may also be wondering what happens to you if you do not defend a lawsuit. When someone sues you, they file a statement of claim. You have a certain amount of time to respond and defend yourself, and this is 20 days if you're served within Ontario. If you don't, you get noted in default. This means the court assumes that you agree with everything the person is suing you for, and you lose the chance to argue back. So it is serious, and it does mean that if you're served with documents in Ontario, you need to pay attention to those documents. And it says right in the statement of claim that you have 20 days to defend. So this is what happens if you don't do that. The first step after would be the plaintiff would obtain a default judgment. Once the defendant is noted in default, the plaintiff can ask the court to make a decision without the defendant's input or ability to defend themselves. This is called a default judgment, and this is how it works. First of all, the plaintiff can ask the registrar to sign the default judgment for specific types of claims, and this includes money owed or specific debts, possession of land, possession of personal property, or mortgage issues like foreclosure. The plaintiff needs to fill out a form called a requisition, which includes the details like the type of claim, any partial payments made, and an interest calculation, if applicable, plus costs, so they can seek their lawyer costs as well for having to bring that default judgment. The other way to get the default judgment is by motion for judgment, and this is under Rule 19.05 of the Rules of Civil Procedure, which is the rules that govern this type of issue in Ontario. If the claim doesn't fit within the types that I just listed, which are quite straightforward, then the plaintiff can ask a judge for default judgment. This involves a court hearing where the plaintiff presents evidence, usually through written statements, affidavits, and the judge has three options: to either grant the default judgment, to dismiss the case, or to order a trial to hear more evidence. Some key points to remember in terms of default judgment are, first of all, the registrar's role. For straightforward cases like owing money, a court official like the registrar can just issue the judgment. The other important thing, though, to remember is the judge's role. For more complex cases, a judge is going to be the one to decide what happens next. The other important thing to remember is even if the defendant does not respond, the plaintiff still has to prove their case to get a judgment in the cases that don't fall within the ones that I mentioned initially that are just for money. It's also important to keep in mind that the facts must support the claim. The plaintiff doesn't automatically win just because the defendant didn't respond. The facts must clearly show that the plaintiff deserves to win judgment. In conclusion, if the defendant ignores a lawsuit in Ontario, the plaintiff can move forward and potentially win by default. However, they must still prove their case, and this process ensures the fairness of the judicial system and that judgments are based on solid evidence, even if one side isn't participating.